A Napa guy knows the only way you'd give a freshly minted driver a brand new car is if he promises to never drive it. Instead, let him grind the gears and knock over the neighbor's mailbox in something a little more suited to his skill level. And with over 400,000 parts and a little Napa know-how, he can safely drive something that's nearly as old as he is. It's not perfect, but it's perfect for him. That's Napa know-how.
Blog Talk Radio.
Good evening, everyone, and welcome to the King Jordan Radio Show for this Thursday, July 7th. This is King Jordan you're listening to. Tonight on the show, we got three big topics that we're going to tackle with our expert in just a second. Well, I will introduce her. Oscar Pistorius, only getting 6 years and could possibly get out in 3. That is mind-boggling, to say the least. Michelle Carter, who allegedly urged her boyfriend to commit suicide. We'll have the full story with our guest. Also, we have, there was a podcast called Serial, and it led to what they're saying is a new trial for this guy. We'll talk about that and some more other stuff that's going on in the world here today. Of course, we have all that shooting, which is terrible. But nonetheless, tonight we're joined with the Dean of Journalism covering trials and stories. She spent time on the Turner Network, Court TV, and just this week she was on Dr. Drew. Ladies and gentlemen, you don't get a great guest like this every day. With that in mind, let's bring in the owner of Karas on Crime. Ladies and gentlemen, please welcome to the show, Beth Karas. Good evening, Beth. How are you?
Well, hi, Jordan. Thank you for that very nice introduction.
Let me get your pulse on the shooting and with Louisiana and all over. I mean, have you ever seen such stuff in your lifetime?
Well, you know, we're seeing too much of it. However, we don't have the full stories yet. And it's awful. What's being captured on videos and what we're seeing is just terrible. It's never a good thing to watch somebody dying, being shot and dying. And these officers are on administrative leave right now. So, I'm just waiting for the full story to come out. But it is quite shocking. I've been defending the officers in the Freddie Gray cases only because these are not cases of a chokehold and a shooting. And, these officers were putting Freddie Gray in the back of a van. They had arrested him. And, it's bearing out. My position is bearing out because the judge is acquitting all of them in these bench trials. But I always say, these are not shootings. Here now we have these shootings. Anytime there's a police shooting and a fatality, they always get thoroughly investigated to make sure it was a justified shooting. Most of the times they are, but not always. And, a lot of people in the inner city, the black communities have said police departments are just way too quick to pull the trigger. And, it's an experience that a lot of people can't necessarily relate to. So, you have to understand where they're coming from. And, these may be unjustified killings. I don't know.
Yeah, absolutely. In hindsight, do you think it was a little rush to judgment on the prosecution for Freddie Gray?
Yes. I thought that right from the beginning.
You didn't hesitate.
She did a thorough investigation. She said it was 3 weeks after he died. He died April 19th. She announced charges on May 1st. So there are major problems with the case, and we're seeing it now.
And as a former prosecutor, when defendants elect to go for a bench trial as opposed to a jury trial, that's serious stuff. I mean, they're putting their hands in the judge, most of these people, right?
Yes, and it usually isn't something that defendants will do because they feel
Right.
that all they have to do is convince one, at least to hang the jury and get another shot at it. You have to convince one out of 12. Here, you have to convince just one. And if you lose, if you don't convince that one, that's it. So it's over. But the lawyers were convinced it was a crapshoot the first time, but they were convinced that the judge would see through the nuances of, regulations versus laws, and the judge is a former prosecutor. He's African American. He understands the case as well, and so it was a crapshoot. But they prevailed with Ed Nero, the first officer to waive a jury, and then with Cesar Goodson, and now the remaining trials are all going to be bench trials. So we'll see. I mean, it's not to say the judge isn't going to find guilt on something. He just hasn't yet.
Right. And, we'll get to the stories, but I look at the Eric Gardner, that one looked to be a slam dunk case in terms of, you have it on tape, the man saying, I can't breathe. I mean, and then you have the, hearsay with the Freddie Gray. I mean, compare the Freddie Gray to Eric Gardner, what you say is much different, right?
Yeah, it's much different. Eric Gardner's the Staten Island chokehold case, and a grand jury refused to indict the officer. I'm told that even the prosecution was shocked at that. They did expect some charges to come out of it, but they wouldn't release the grand jury testimony. Unlike in the Ferguson, Missouri case of Michael Brown, that grand jury testimony has all been released. So, I don't know what to say. The grand jury is the conscience of the community. A grand jury is in lieu of a preliminary hearing. Some places do a preliminary hearing. Some places do a grand jury. Some places do both. But in New York, we primarily do grand juries. And the grand jury, the 23 citizens who sit in judgment of whether or not there's enough evidence to even bring charges, chose not to charge the police officer, and as I've just said, they're considered the conscience of the community. Let the community speak, even before there's a trial.
No question about it. I want to start off with Charlie. You've been covering. It's the indictment for the girl who urged the boyfriend. Here is a little clip of the background, and then we'll talk about it on the other side.
According to the Associated Press, on Friday, the Supreme Judicial Court ruled in favor of the indictment of a teenager who sent messages encouraging her boyfriend to commit suicide. In 2014, 17-year-old Michelle Carter sent her boyfriend, 18-year-old Carter Roy III, dozens of messages to continue on his mission of taking his own life. She reportedly told him to get back in his carbon monoxide-filled truck after Roy began having second thoughts. Michelle Carter will now stand trial for involuntary manslaughter.
All right, Beth Karas, you were on Dr. Drew yesterday talking about this, I believe, with Lisa Bloom. What's your take on this story?
Well, I've been waiting to see what the court was going to do because I thought that maybe they would throw it out on First Amendment grounds, but no way. First Amendment grounds meaning she was speaking, she was using words only, she wasn't anywhere near him when he died, and she didn't give him the instrumentality of death. She didn't provide him with the mechanisms, for example, to kill himself. What she did was give him the encouragement. Well, he was a very vulnerable person. He had been treated for mental illness since 2011. His death was mid-July 2013. So what's the date? 7th. He died on I think it was found on the 13th, so he died on the 12th, and in a shopping mall or parking lot of a store or something. In any event, she knew his vulnerabilities. They lived in different towns. They had a largely electronic digital relationship. They weren't together all that much. They had dated on and off for a couple of years. So he had attempted suicide in the past with acetaminophen, and when he was making the decision to do it, we see from the hundreds of text messages, many of which were in that Massachusetts Supreme Judicial Court decision that came out last Friday and is on my website, you see how she was encouraging him. I mean, and demanding, as you just noted in the piece you just played, demanding he get back in the cab of the truck when he got out and he was chickening out. Like he really didn't want to die, it seems. And she said, your family will get over it. And, you need to do this. What you always say you're going to do it, and then you don't do it, and you need to carry through. You've got to do this, and everybody will be fine, and I'll look out for your family. And after the fact, she also asked him to delete the text messages, which he did not do.
No.
And after the fact, she learned that the police were looking at his phone, and she texted a girlfriend and said, I could go to jail. I could have stopped him. I could have called the police, but I didn't. I could have called 911, but I didn't. So, she knew what she was doing was wrong. I'm not sure what satisfaction she gained out of this, unless she's a little unstable herself.
Yeah, and from the initial text, from what you understand, did he want to commit suicide because of the way his life was, and
he was
just
he's
saying
a teenager.
get out of this work. Yeah.
Yeah, he was a teenager. I think he was 18. She was 17 at the time. I know she was 17, but I believe he was 18. And he was mentally ill. And, it's hard enough being a teenager, even though he's approaching his adult years. It's hard enough being a teenager with all your hormonal changes and stuff. And
sure.
Who knows what else was going on in his life. Plus, he had depression. And sometimes depressed people just want their depression to end. They want their sadness, their pain to end. They just don't want to live anymore. But there's help. There's help for them. And he had his life ahead of him. And she could have prevented him. He was vulnerable, and she could have stopped this. She could have called his parents and said, he's really sick. She could have called the police. So, did he really want to die? I don't think he did. He got out of the cab, he chickened out, and she ordered him back in.
And there's evidence that she kind of had like a visual for him. She cared for him, things like that. She was like really. It showed on some sites that she was really to him in terms of a good friend. But then I could argue what friend would do that. So
I don't know if this was. I don't know if she wanted like attention afterwards and having a memorial and whatever, she wanted attention for herself or doing that. I don't know. I don't know enough about her. All I know is Massachusetts does not have an assisted suicide statute on the books. Some states do. They make it a crime to assist in the suicide. We saw Jack Kevorkian go into trial a lot under Michigan's law years ago for assisted suicide, and jurors just would nullify. It was clear he was doing it, but they would nullify, and they believed in what he was doing with the terminally ill. But the court in Massachusetts made a point of adding a line or two in the opinion saying this is not a situation of assisting in the suicide of a terminally ill person. And so they were without saying more, they were kind of contrasting it with a mercy killing or a Kevorkian type situation. But Massachusetts, they have an involuntary manslaughter statute. And under that statute, in order for her to be found guilty, the court had to find that what she did was it's wanton or reckless conduct. It's a wanton or reckless conduct or a failure to act, wanton or reckless failure to act. But they found what she did was really reckless in encouraging him to kill himself. And the reason the First Amendment argument, at least at this level, didn't survive is they said, look, we've got an interest. The Commonwealth of Massachusetts has an interest in preventing people from killing themselves, and you do not have a right to encourage someone to kill themselves if what you are doing is if there's a link between between your words and somebody harming themselves, then we are going to protect the rights of the person who's being harmed over your right to speak.
Yeah, it sounds like she was pressuring him almost to just get it over with. It's not like, think it over, this and that. She plain out in the text said, get it over with, kill yourself, or it's that effect, right?
Now, one of the reasons it was appealed was because she was charged as a youthful offender also, and the defense didn't want that. She was 17 years old, which means she was squeaking in under juvenile law, which would allow her, if she's going to be prosecuted, just to serve juvenile detention until she's 21. And a lot of times juvenile records don't follow you as an adult. You know, you're not convicted of an adult crime. You're not treated as an adult. But youthful offender treatment in Massachusetts is discretionary with the prosecution for serious crimes, and the prosecution can decide whether or not to basically try her as an adult. And youthful offender allows the court to sentence her as an adult or as a juvenile, or a combination sentence, like juvenile detention until she's 21, and then, or maybe even 18. She could go to a prison at 18, and then send her to a prison for a couple of years. I don't know. I mean, but the appellate court on Friday upheld this youthful offender treatment. They said it's fine. This is a good indictment. And now she faces a potential 20 years. She could get a lot less than that, or she could get a combination.
Wow. Very interesting. We'll be following that. Let's take a listen to Oscar Pistorius and the low sentence, and then we'll talk on the other side.
Oscar Pistorius entering court, facing 15 years for murder. It's the final act in a legal saga and soap opera that has gripped South Africa for several years. But from the opening moments, Judge Thokozile Masipa seemed ready to hand out one more surprise.
Murder is always a very serious crime. The fact that the accused thought it was an intruder does not make it less serious. Serious as the crime is, for purposes of sentencing, it is always useful to place facts that led to the particular murder in perspective.
She said there were substantial and compelling reasons to give him less than the mandatory minimum sentence.
He reiterated that the accused showed no remorse, as he did not come clean before this court. I disagree.
The judge agreed with the defense's argument, which it dramatically illustrated in court during hearings, that Pistorius was a broken man, highly vulnerable on his stumps when he shot Reeva Steenkamp 4 times through a locked bathroom door.
He suffers from an anxiety disorder. We know that the uncontested evidence was that when he was on his stumps, his balance was seriously compromised. And without anything, he would not be able to defend himself.
Mr. Pistorius, please rise.
But the judge ruled Pistorius still needed to be punished for his crime, that Steenkamp's family will never get over her death.
I don't wish that on any human being. Finding out what happened, it devastated us.
6 years imprisonment.
The sentence shocked some, but Masipa said it was for the court of law to decide, not the court of public opinion. Pistorius should now be heading to this private cell in the hospital wing of a maximum security prison. After just 3 years, he could be released on parole. David McKenzie, CNN, Pretoria, South Africa.
All right, Beth, what do you make of this story with only 6 years, possibly 3? It's the same judge that initially gave him a lighter sentence. I mean, this is really not just, a lot of people are saying.
Well, this Judge Masipa had presided over the trial, and she had found him guilty of the lower offense of culpable homicide. And the system is very different in South Africa because the appellate court could change the verdict and put in a murder verdict and send it back for sentencing. So that's what happened. And I think it's a real slap in the face of the appellate court because she gave him virtually the same sentence. Now, the law in South Africa allows a judge to depart downward from the mandatory 15 years for substantial and compelling reasons. I think those are the buzzwords. But it's not a defined term. And some legal experts there think that it's really not to be used very often. I mean, it's pretty much a 15-year sentence unless there's something really extraordinary. And this is now considered an intentional killing, and it doesn't matter if he thought it was an intruder and not Reeva that he was shooting at in the locked bathroom. He intended to kill whoever was in that bathroom. And
right.
the judge still seemed to give him a break because he thought it was an intruder, in addition to his remorse and all that. She gave him a huge break. Now, that's an appealable sentence. The defense has already said,
really?
The defense says,
okay.
We're not going to appeal it because we're happy with it. Heck, I mean, they're not going to do much better.
That's a home run for them.
And if they did appeal it, the appellate court could make it longer. But the prosecution can appeal it. Yeah, sure, they can make it longer. It's a very different system. So, but the prosecution may be appealing it. So we just need to monitor the story and see if indeed they file a notice of appeal and ask an appellate court to give him a longer sentence.
Has he spent any time in jail?
Yes, he spent about a year, I believe, and he'll get credit for that. Not credit for well, I shouldn't say he's not going to get credit for the house arrest. He's been living at his uncle's on house arrest. But it doesn't work in the United States to have house arrest count as incarceration. So I can't imagine they would allow it in South Africa. That's a type of detention in lieu of bail or as a bail condition as opposed to serving time.
Something like this happens here in New York City. What is the defendant going to get, in your opinion, as a former prosecutor?
Typical murder is second-degree murder in New York, and depending on it's first-degree murder if you kill, a cop or a witness or something like that, and then it's life without parole. But second-degree murder, which is what this would come within if it were murder, in New York would be 25 years to life.
Wow. So you're looking at a difference of 25
years, and then you're up for parole. Yeah.
Wow. All right. This last story is very interesting with this podcast. Here is the sound from it, and then we'll talk on the other side.
Serial shocker. After spending 17 years in prison, Adnan Syed, whose case became famous with that popular podcast, he's getting a new trial. ABC's Lindsay Davis here with the latest. Good morning, Lindsay.
Good morning, George. Social media is abuzz with Serial fans sounding off about the subject of the first season of the Serial podcast getting a new trial. Some are celebrating, some say he's still guilty, but just about everyone seems to agree that the podcast deserves a lot of the credit for the retrial. This morning, convicted murderer Adnan Syed is getting a second chance to prove his innocence, now that a judge in Baltimore has ordered a new trial for the subject of the 2014 Serial podcast.
This is a prepaid call from
Adnan Syed.
Syed's story captivated millions of listeners. In 1999, at just 17 years old, he was convicted and sentenced to life in prison for murdering his high school ex-girlfriend, Hae Min Lee.
It is what it is. If someone believes me or not, I have no control over it.
All along, he's maintained his innocence. And while his initial attempts to appeal were unsuccessful, now, at 36 years old, after spending more than half of his life in jail, a judge has signed the order for a new trial.
The conviction is erased. It's gone. He's not, as of this day, he's not convicted anymore.
In the order, the judge cites the defense's decision to not cross-examine a state witness about the reliability of cell tower evidence. The judge also questions why the defense had not spoken to a possible alibi witness, a major plot point in the podcast.
If there was some technicality, something that would prove his innocence, great,
But I think, Asia, you might be that technicality.
Asia McClain, a classmate of Syed's, says she was with him in the school library at the time prosecutors allege Lee was killed.
Do I think Adnan killed Hae? Honestly, I couldn't tell you. By coming forward, I hope that I was able to provide enough information to the judge for him to be able to make a rational decision.
On Thursday, McClain, who just gave birth, tweeted, "Wow, I'm speechless. New baby, new trial."
Statistically, it was over. So we have come back from that. I can't emphasize enough that there's a lot more work to be done, but we're feeling pretty confident.
The Maryland Attorney General's office released a statement to ABC News saying the state's responsibility remains to pursue justice and to defend what it believes is a valid conviction. Lee's family has long said they believe Syed was the killer. George.
Okay, Beth Karas, this is odd. A podcast makes, it is basically the reason why this guy and the podcast person who was running the podcast thought he was guilty, but she did the trial anyway. And what's your take of it?
Well, I thought it was a fascinating series on Serial, season 1. Listened to all of it, and really, it's the subsequent podcast that's not related to NPR called Undisclosed that's responsible for coming up with the cell phone and the cell tower information that really is the reason he got a new trial. The alibi witness is part of the NPR Serial podcast, but the court said, well, that's not ineffective assistance of counsel, but the cell tower cell phone information is. And that other subsequent podcast really dug up some interesting information. This was 1999, and the Syed case was one of the first times, apparently, that cell phone records and cell tower information like this was used at a trial in Maryland. It was one of the earlier cases. The expert has since recanted what he said because he wasn't shown a cover sheet fax that came with the phone records, and that fax had a statement on it that was really important. It said, outgoing calls only are reliable for location status to determine the cell tower and the ping and where the phone is at the time of the call. Incoming calls will not be considered reliable information for location. And apparently there were 2 incoming calls at a little after 7 p.m. on that day in February, I think it was February 1999, in the park where her body was found in a grave. And that was corroborative evidence of the kid, Jay Wilds. Many people feel he's hiding something. And the prosecutor even apparently said, Jay Wilds alone, maybe not believable, but combine it with the cell phone records, that's proof beyond a reasonable doubt. And now those cell phone records are in question.
Okay, we do have a caller. Let's go out to where are we going to? We're going to say hello to Sarah. Sarah, good evening. How are you? Welcome to King Jordan Radio, Huntington Beach, California.
Jordan. Hi, Beth.
Hi.
Hi, Sarah.
Just a couple things, because I'm sure there's lots of people that want to call in. As far as Michelle Carter goes, I read all the documents, and everyone that's listening, Beth Karas has the best website. Everyone needs to do Karas on Crime. It's chock full of so much information.
Thank you.
So I did read all the documents, and I'm a little bit nervous because I think she did a very, very bad thing. And I hope that her defense doesn't come out and say, well, she's mentally ill as well as he was. I mean, I don't see that she was. I just kind of see her as a very, very cold, calculated person with so much opportunity to call for help for this young man, and it's just really, really sad. So I just wanted to just say that I hope she does get prison time for what she's done. I mean, I don't know, being that she's 17, I mean, should she get 20 years? There then you have to think about, well, their brains aren't developed till they're 25, and it's very, very difficult for anyone in that age bracket to say should they have their whole life taken away. But then again, look what she did. But I do think she deserves some prison time, and
maybe she'll be in the detention, the juvenile detention till she's 20,
and then get the combination, right?
Yeah, maybe.
Yeah, I hope so. And as far as Oscar Pistorius, gosh, I mean, is everybody just tired of him already? I think that I was so shocked to know that the appellate court can change the verdict. Not that they would order a new trial, but they can actually change the verdict. I was astounded. I didn't know that.
Yeah, so we saw that in Italy, too, with Amanda Knox.
Right.
She was guilty, and then she was not guilty, and then the higher court said she's guilty, and it was craziness. But it's very different around the world compared to
very different
in
the United States, because I just think Casey Anthony, she was very lucky that our system doesn't do that.
Right.
Now, as far as Adnan, it is troubling about these cell phone towers. But on the other hand, I'm thinking, who else had motive for killing this young woman? And do you think that it's like the state has anything more than the cell phone towers? Because these two witnesses, the girl who says she saw him in the library, where was she for the first trial, Beth? Do you know?
Right, Asia McLean. I don't remember. At the time, I was more up on the facts of that, but I do recall there being an issue in her recollection because of a snowstorm, and so that she's going to get cross-examined on that because she might be off on her day, on the day that happened. I
and
seem
then
to
the
recall
young man
being an issue with that.
Oh, okay. And then the young man who says that he helped hide the body or whatever. I mean, I wonder, has he been looked at? I mean, what if Adnan is innocent? Maybe he did it. Maybe, he knew so much about everything. But
well, that's what some people think. If it's not Adnan, it's Jay. So that's what a lot of people think. I flip-flopped the whole time, and what did it for me was the cell tower information. I remember thinking, oh, please, the phone was pinging in the park when they were burying her body. And then when I heard that information is called into question, I was like, oh, boy, now I got to reevaluate the whole thing again. So.
Yeah, it was shocking for me, too, the cell phone towers. Anyway, I'll let everybody else call in. Great talking to you, and
Thanks,
you take
Sarah.
care. All righty.
Thanks,
Bye-bye.
Sarah. Appreciate it.
Thank you,
so
Jordan.
Okay, sorry to cut you off there, but before we let you go, Beth, I wanted to get your take on Nancy Grace, and I wanted to get your information about your website, how it's doing, how the audience can obtain it. Now, with such not too much news on TV, the only way to go is the Internet. And as you heard, one of our listeners definitely recommends it. So with that in mind...
all right, well, let me just answer the
thought.
Nancy Grace question quickly. I mean, I don't really have any more information than anyone else. I have friends who work on the show, and they were at the big meeting on Thursday when it was announced. It was a 9:30 meeting. Nancy was on a video conference telling them that, she had decided not to re-up the show, not to re-up her contract. And so the last show was going to be sometime in the middle of October. So they still have, some months to go. I don't know what she has in store, but her kids are getting older, and maybe she wants to spend a little more time with her kids. And, maybe, I have no idea what HLN is going to put in that hour also, and they didn't announce it. So I haven't spoken to Nancy. I will reach out to her at some point in the near future, but I haven't.
And you know Nancy for a long time, right?
Oh, I've known her since the day she walked through the doors of Core TV. I was there before her, and
really?
We used to be
next
door to each other. Our offices are right next to each other.
What year was Core TV started?
She
93,
came.
92?
I joined Core TV in '94. Right at the time that OJ got arrested, and she came, I want to say sometime later in '95. After, was it? I don't remember if it was before when his trial was still going on or after. No, would have been after or maybe '96 because she got hired for a show, Cochran and Grace, and Johnny Cochran obviously had finished the trial. So maybe in '96.
Wow.
Ricky Kleeman came in '95, and then Nancy Grace.
And then subsequently it became a True TV, and then
it became True TV, and in session on True TV in 2008.
Right, and then after the, like I was saying last week to my panel, the cases were good for the Nancy Grace case. We haven't had that eyeball staring case, i.e. Jodi Arias. I mean, I guess they were getting ready for that hot car death trial, but that's been postponed for a while. But we really haven't had that case. Yeah, we really haven't had that Casey Anthony, which is 5 years ago, 2 days ago. The verdict was reached 5 years ago, 2 days ago.
The anniversary, right? The 5 year.
Yeah.
5 years? Oh my gosh.
5 years ago. What was your take there? Where were you in?
For trial watchers, it does hurt that there's no network that promote
Nothing.
these trials, because it really, puts the trial on everybody's radar, and then everyone starts covering it, and now it's just kind of scattershot, and we're all looking around and hoping that somebody's going to stream it. There's still a lot of, manpower and labor that goes into streaming if you want to do it right, setting up enough microphones and cameras and making it good broadcast quality. You don't just plop a camera in the back of the courtroom and get the backs of everyone's heads and bad audio. You can't hear. So it is, there's a commitment. There's a financial commitment and a time commitment to covering a trial.
Sure.
And I know, like in local markets, a local TV station isn't dedicating all that equipment and personnel for a long trial, but they'll pop in periodically. So.
And I would imagine, I was just thinking the Bill Cosby, which was a hearing today, as you probably know, that will have a lot of eyeballs, even though I think in Pennsylvania you can't bring cameras in, right?
No cameras in criminal cases. So
right. But
that will never.
Like Michael Jackson, there'll be people outside of the courthouse reporting on this icon that might be taken down.
Right. And the big cases, I was at one of Cosby's hearings. The big cases that I have covered or have some exposure to over my career, where it was a big zoo outside, but no cameras inside, were Michael Skakel, the Martha Moxley murder in Connecticut. Michael Skakel.
Is that
Michael Jackson, child molestation.
Mickey Sherman?
Yes, Mickey Sherman. So it's Michael Skakel, Michael Jackson's child molestation, and Martha Stewart. I was at her verdict.
That's like 10 years ago, right?
Puffy Combs. P. Diddy, I was at his trial. There wasn't a camera in New York that I recall,
P. Diddy, right? Yes.
There were more. I'm trying to think off the top of my head, but I'm a little tired.
Do you remember who represented Diddy?
Pardon me?
Do you remember who represented P. Diddy?
Yeah, Ben Brafman.
Ben Brafman.
Whose partner of counsel is Mark Baker. The appellate guy was a really good friend of mine. I've done a podcast with him on his shaken baby syndrome case. And Ben Brafman introduced me to he was Puffy at the time. He wasn't P. Diddy. He introduced me to him, and he had a very limp handshake.
Oh, he was Puffy? He's been through so many name changes.
You judge a person by their handshake, Jordan. You got to have a firm handshake and look a person in the eye. You judge a person by the handshake, and Puffy didn't have a good one. But he probably was annoyed that he had to shake my hand. I'm sure he was annoyed.
But you were, one and only Beth Karas. A lot of people are very interested. Now, what is you have a
okay? So my website, as you know, thank you for mentioning it at the beginning, is KarasOnCrime.com.
I always go to your website. It's great. KarasOnCrime.com, and I launched it to cover Jodi Arias' retrial, and I've just kept motoring along since her trial ended. Is it 2 years now? I started it in October 2014, so not quite. A year and a half. Okay. It's a good place for me to write blogs, and I do videos, and podcasts are my favorite. I love interviewing people, and I just did one with a bloodstain pattern analysis expert out of Memphis, Tennessee, who's worked on some big cases. And it was, we talked for an hour. So it's fun. It's kind of like what you do, doing radio stuff, but I record these podcasts and put them on my website. So I got another good one coming up soon with a private investigator. In any event, podcasts, blogs, documents. I get a lot of court documents, and I answer questions. I do live chats. I just did a live chat tonight before we talked, and so I interact with my members, and I answer their questions, too. A lot of people have questions about the law, and my philosophy is whether you spend 5 minutes or 5 hours on my site, I want you to come away more informed and a little bit smarter. Right, and I'm sure you'll have full coverage of these Minnesota case stuff that went on and the cop thing that's going on. As more comes out, I'll be following them, sure. I have a lot on the Baltimore cases because I've been, following Freddie Gray from the beginning. Freddie Gray.
But my site is not free. It's subscription because I was living in Arizona, and so it helped me to live in Arizona for the Arias trial. So anyway, it's a subscription site, but you get a lot from me. So join for a month and see if you like it.
So you join for a month? Yeah, that's the best way to go. Karas on Crime.
Like 2 cups of coffee. $5.99 if you're recurring. $5.99 a month if you're recurring. $6.99 for 1 month only.
Dunkin' Donuts coffee.
That's right.
More than that. Beth, have a great rest of your summer. Thanks so much for